Hello, this video is part of a series of resources for Texas commercial property owners. I'm Pat O'Connor with O'Connor & Associates, and the topic for today's video is, should you continue your property tax appeal after the Appraisal Review Board hearing? And the answer is, in most cases, an emphatic yes, absolutely. And the reason is, the appraisal district has a series of artificial and inappropriate rules that they apply in considering how they value property. For example, your property may be master metered for utilities, but the appraisal district says, well, I'm sorry, your expenses are just too high. We only allow 50% for expenses. Or they may say, well, I understand your property flooded and there's $3 million worth of flood damage, but that's covered by insurance, so we're not going to allow you to take it off your taxes too. Well, of course, that's just plain wrong. The issue is the value of the property, not whether or not you have insurance. So let's consider a sample appraisal district that has maybe 500,000 properties to value. And of these, they get rid of 80% of the property owners because they don't even file a protest. Of the 20% or 100,000 who do file a protest, they get rid of about 60% or 60,000 with a token reduction at the informal hearing. And the remaining 40,000 who go to the Appraisal Review Board hearing, well, the appraisal review boards tend to be much more favorable to the appraisal district's evidence than to the property owner's evidence. So if you really want to have a serious conversation with the appraisal district, and if you want any consideration on unequal appraisal, it is necessary in most cases to continue the appeal after the Appraisal Review Board hearing. So of the 40,000 who had the Appraisal Review Board hearing, maybe only 500, just a tiny fraction of all the taxpayers in the county, will file a judicial appeal or file for binding arbitration. And now the appraisal district has the time and staff to have a serious conversation. And so you're talking to the appraiser and you're saying, well, the issue I had was my expenses are higher than you normally consider because my property's master metered and I pay all the utilities. And the appraiser goes, they didn't consider that at the hearing? And they go, no, they said the maximum you can consider is 50%. The appraiser goes, I can't believe that. No, let's get that fixed right now. Yeah, we can take care of that. Or you may have the situation where your property flooded and there's $3 million in flood damage, and you're talking to the appraiser after you filed the judicial appeal, and he goes, and you're saying, well, the big issue here is the $3 million in flood damage. And the appraiser goes, so what's the problem? He goes, well, they told me they couldn't consider it because I had insurance. And the appraiser goes, you're kidding. They didn't really say that, did they? And they go, yeah, the appraiser and the Appraisal Review Board said, no, we're not giving you that. You have insurance. And plus, we've been giving you replacement reserves for 20 years. Well, neither of those are realistic arguments or valid arguments. So if you want to have the appraisal district reduce your value to the appropriate level and get the lowest level of property taxes, if you want any hope of having a discussion on unequal appraisal, strongly consider continuing the appeal after the Appraisal Review Board hearing with either binding arbitration or a judicial appeal. Our experience is it's the only way to have a serious discussion without arbitrary and capricious boundaries set by the appraisal districts. To find out if you're fairly taxed, go to the Texas Fairness Checker at cutmytaxes.com. It's free and takes less than a minute, and you'll find out if you're fairly taxed or not. This is Pat O'Connor with O'Connor & Associates, and we'll be back soon with another tip.